So welcome everyone. Delighted to be here today. I've done almost 30 of these webinars since this entire pandemic started. And this is the first time I get to ask the questions, not answer the questions. And I will tell you, I'm not going to do to you what's done to me by James Donnelly of Castle, which is lightning round questions. We didn't go over that. I'm not going to subject you to that. I want to introduce our panel. Some of these people I know quite well. So Regan Maroc, I've known Regan, God, I've known you for ages. Regan is the chairman of the Kent Task Force. We're going to be talking a lot about Kent Task Force today. Regan's been in the association management industry for more than 15 years. And frankly, you're one of the best connectors of anybody in this industry I know. So Regan, happy to have you here.
Donna, thank you for having me.
Now, next up is Darren Mcdonough. He's Vice President of Kent Services. Darren is also on the Kent Task Force. Darren is a 23-year U.S. military veteran. By the way, thank you, Darren, for your service. Blown away by your resume here. You've served various roles, including Special Forces, and you were the recipient of 2 Purple Heart Awards. Amazing. You retired with the rank of Major. You're a former professor at FIU, and you hold a PhD in Strategic Security Studies. So basically, you haven't accomplished much yet, Darren, but you know, hopefully you will in the future. Welcome to the panel. Next up is Liz Martis. Liz is the Director of Human Resources at Kent Services. Liz is also on the Kent Task Force. Liz has over 15 years experience in human resources. You've worked, Liz, I understand, with all types of companies, big and small, including working with the United States Postal Service. Is that correct?
No, it's actually UPS.
Oh, UPS. Well, you must
Yes.
have some stories from UPS. That's a big company.
Yeah.
You hold a master's degree in human resources, and delighted to have you on the panel.
Thank you. Thank you for having me.
And then last but certainly not least, Andrea Northrop. Andrea is the Vice President and shareholder of Insurance Office of America. She's also former Vice Chair of the Real Property Insurance Committee for the Real Property Probate and Trust Law section of the Florida Bar, also a member, Reptile. Andrea's also a lawyer, fellow lawyer. And 2 things I didn't know about you, Andrea, that you went to the University of Missouri. My daughter went to WashU in St. Louis, and you went to Kansas City Law School. So 2 new things I learned about you. Andrea's my go-to insurance expert, so happy to have you on the panel.
Thank you. Happy to be here, and I really look forward to today's conversation.
Wonderful. So I understand we have about 800 people that have registered today, and I will be looking at your questions as we go. But I want to kick this off with Regan. So Regan, why don't you give us an overview of what this Kent Task Force is, when it was created, and what it does?
Sure, Donna. Donna, just a foundation for Kent Services that the Kent Task Force is affiliated with. You know, Kent is a 38-year-old national private firm with offices all across Florida, New York, Washington, D.C., on the West Coast. Just as a perspective of clients, the state of Florida, the city of Miami, Jackson Memorial Hospital, which obviously is very busy at the moment. The task force was basically, the preparation started about 4 or 5 months ago, and it went live in May. And it's comprised of 5 task force members, obviously 3 on the phone today, with backgrounds in real estate, law enforcement, military, HR, and janitorial. And the task force basically has 2 main missions. One mission is to help associations with the planning and preparation of their reopening their amenities. And the other is, you know, even prior to the protest, working with businesses and associations to evaluate their physical security and make sure that for, as I call it, America 2.0, people are ready and thinking ahead.
Okay, great. And we're going to talk a little bit about that later, about the security issues related to the pandemic and basically what we're seeing today. But Darren, I want to ask you, so what are you, I don't normally think of a security guard as stepping in to fill these functions, whether it's, forcing people to socially distance at the pool, wear their facial coverings when they're wandering the community, restricting access to visitors. Some communities are still doing that to a certain extent. So try to help us wrap our heads around the ideas of having security officers fill these new functions.
Sure, I get that question quite often. I'd ask, people that are on the webinar now to just think about your officers that are in a residential setting. They're inside a high-rise or gated community, and the things that we ask them to do on an everyday basis, it doesn't really differ that much from enforcing social distancing or wearing a mask. Security officers are there to enforce community rules, so it really depends on how you say it, how you approach the professional manner, the customer service approach to just saying, hey, we need to be 6 feet apart, or we're requiring to wear a mask. It's the same as asking for an ID or saying you can't have glass in the pool. So we don't really look at it as too much of a stretch from what we're already asking a qualified officer to do.
Okay. So Liz, I'm going to throw it over to you. What are you looking for when it comes to hiring people now in the time of COVID to fill these roles? What specific skill sets are you looking for?
Well, we need people that are obviously certified to be a security officer. That's not, haven't changed. But mainly we want people that understand what is it that they need to do in addition to the typical officer's responsibilities, right? Because as we just mentioned a few minutes ago, now they have to expand into the typical role and be aware of things like making sure that people are observing social distancing guidelines. So enforcing rules like that is something that they absolutely need to be mindful of when we are sending them to work with the different clients, especially in a residential community where you have, visitors coming in. Now they have to ask questions like, have you been out of the country? Every property have the different guidelines, and they need to understand what those are in order to serve those clients to the best of their availabilities. And we provide training to them in order to make sure that they are fully prepared to take along those responsibilities that perhaps were not part of their world until we got hit, if we could say that, with COVID-19.
So, some counties, like Broward County, specify in their emergency order no guest usage of the pool. So that's crucial. You don't, as a board, want to be operating below the requirements of the applicable county order. So this is where that questioning that you just referenced, Liz, is going to be so important, which is, hey, check IDs. Are you actually a resident here? Or is it somebody's friend whose maybe community has not reopened their pool, which is now trying to use this pool? I would imagine that you want to strike the right balance in terms of the personnel you use, that they are not too timid to fill this function, because it means it's going to require some communication and perhaps dealing with pushback, but also not hotheads. You don't want somebody who's going to quickly escalate the situation. Do you use personality tests? Is that still a typical industry metric when hiring?
Actually, we do use it here at Kent. We have something called a predictive index that is basically, an assessment of their behavior and how would they react. Because in fact, as you mentioned, we need to make sure that we're sending to our clients the right type of security officer. So we do use our predictive index.
Oh, great. So Andrea, who's always either the most popular or the least popular on these panels, because we're talking about insurance, and so much of the decision making really boils down to, is there any coverage for these claims? Now, I looked right before I hopped on here and I jotted down a few numbers. Right now, as of today, we have 380,000 confirmed cases in the state of Florida. We have 5,344 deaths in Florida. In some instances, Florida is showing larger numbers than some countries. So I guess what I want to ask you, Andrea, is why is it so difficult to obtain coverage in terms of communicable diseases and the liability associated with them? And has it always been this way? Was there ever coverage for these kinds of claims?
It's a maybe. That's a good law school answer for you there, for maybe. But for the majority of carriers, a number of carriers, I should say, so the forms have existed for a long period of time, and those forms have said that communicable disease is a specific exclusion in the policy itself. So if you were looking at maybe a Southern Owners or an Auto Owners form or a Tower Hill form, communicable disease is listed as a straight exclusion right there. Other association forms would say something like pollutant or contaminant, might have fungus or microbe, that's going to be listed as an exclusion. So from a broad spectrum, the carriers have not wanted to be on communicable disease. They didn't want it to be a flu that spreads throughout the building or a shared laundry facility and you get something that spreads through there. I mean, one time we had a scabies claim. We've seen a Legionnaire's claim. You see all sorts of things that are not COVID-19 related. So the carriers were very much aware of the potentially dangerous nature of a small environment with hundreds of people living in a single, filtration system, and they didn't want to be on the hook for it. You could purchase pollution coverage and try to pick up some of this liability coverage for the mold and the fungus, maybe even like sewer backup or human waste contaminant. But now most of those carriers are adding on COVID-19 exclusions when they're coming up for renewal, and that's what we expect to see moving forward. Ultimately, thinking big picture down the road, we might be able to see something kind of like how the federal program backs up terrorism insurance coverage, or the NFIP through FEMA does flood insurance coverage. There might be some form of coverage that's going to be picked up that's going to be government backed, but that would be my big picture guess for down the road. Carriers do not want this risk.
Well, it doesn't seem to fit with their model of making money, so I can understand that, but it doesn't make our jobs easier. Andrea, we're going to spend a little bit of time today speaking with the Kent Task Force about reopening amenities if their amenities are still closed, or keeping them open if they've been open for some time. From an insurance industry perspective, how do you feel about having pools and gyms open or reopening them in a hotspot like Florida?
I think it was best said by another Becker attorney on a seminar. He said, if I was a board member, would I feel better sitting across the table in a courthouse on a claim where somebody's suing me because they're upset because they can't have access to the fitness room or the pool? Or do I want to be on the other side of the aisle on a wrongful death suit for having reopened it and somebody's claiming they got COVID and died as a result? So I would take that as well from a risk management perspective. If we're analyzing your specific policies that are in place, if we do not have coverage under the directors and officers, because it very clearly is going to say an exclusion for bodily injury, illness, disease, death, sickness, emotional distress, and mental anguish, we've pretty much put a bow over COVID and got it excluded right there, and most likely not under the general liability. I would take a risk management analysis and say, if you don't have coverage, if you engage in reopening, maybe reopening is not the best thing for your community in the midst of a hotspot. It's not ideal, but neither is a pandemic.
I couldn't agree more that the economic damages are more quantifiable. A lost lease, a lost sale, just I couldn't use the pool. An inconvenience isn't really a quantifiable factor. We do have precedent. There was that case in the Panhandle. I think you're familiar with it, where a group of private property owners with their own private portions of the beach sued the county, saying that they couldn't, when the county order up there said they couldn't use, they closed all the beaches, they sued, and the court said, you know what, your convenience takes a back seat to public safety. So we do have some precedent here, and I really could not agree more. I will tell you that in representing my clients over the last 4 months, I've had, I would say, half a dozen letters from attorneys threatening, saying, we're going to sue, you wouldn't let, so-and-so use my client use the pool or use the gym. When we've pushed back and we've told them basically what's in our arsenal, none of it's come to fruition. So speaking of muscle, I'm going to go to Darren again. Darren, temperature taking, right now it's on everybody's, I get asked this a lot about temperature taking. You and I have spoken before. I am not a huge proponent of taking temperatures when it's the association doing it itself. I think there's issues doing it with residents as opposed to doing it with employees. I understand a lot in our association industry, it's comparison. Well, this community is doing it, maybe we should be too. And sometimes it's peer pressure. What do you think about taking temperatures as a tool?
I see both sides of it, Donna. I see, your side where, maybe it's not a risk worth taking, certainly from the association standpoint. We're applying it at a lot of associations now as a step. We make it very clear that, you know, just taking a temperature does not prevent the spread of coronavirus. People are asymptomatic and still could be coming in, but we're taking the measures appropriate, making sure everybody's wearing a mask, social distancing, and then the temperature checking is just one part of it. So having a third party do it, like a security company, I see the value in that and taking that off of the association, because we're certainly not advocating that this is foolproof. This is just one step. And then of course you have to have the protocols. A resident, a guest, you know, what do you do if somebody has a high temperature? What's the association going to agree upon appropriate action? You're going to bar that person from coming in the property. There's lots of issues associated with taking that task on. So,
and people can run fevers for other reasons in addition to COVID. I think that there's a clear distinction to be made between residents, because you can't preclude a resident from returning to his or her property. They have legal rights to access their property. Contractors coming on, I see a different situation there. Visitors, for sure. Again, my big issue and concern was always there, and that these devices need to be used properly and consistently. And, you know, it really boils down to who's doing it. So I'm going to give you the hardest question that I've been thinking about, which is, if there was one thing that you think on the task force that an association could do to minimize the spread of COVID in their community, what do you think it would be?
It's certainly taking steps to limit the amount of traffic and the amenities, which is the part that's applicable for, you know, detecting fevers. Those steps can easily be taken if the community has made the decision to open up the gym, the pool area, library, spa if they have it. Enforcing social distancing, mask wearing, and elevated body temperature is probably the best thing that a security provider can do for an association, because that's where people are going to be mixing together. That with a comprehensive disinfection service is probably the most prudent steps that can be taken.
So you think access control, and I agree with you. I think it's access control, and I think in a multi-family building, it's facial coverings. I think those are the two most important. So Regan, I have a tough question for you. Does the task force have a finite lifespan? Do you envision it continuing, assuming that we combat COVID-19 with a vaccine? You know, we're hearing that the Russians have a vaccine now, that we're going to get one. Assuming we can vanquish this virus in the near future, does the Kent Task Force go on?
You know, that's an interesting question. I think in the beginning it was the time frame was going to be less amount of time, and obviously as time goes on and uncertainty goes on, and even if the vaccine, we find it in the next couple months, its production, we're still talking a couple years out. We also understand that from the task force standpoint, that physical security, which is the other element, all the damage to the economic ecosystem, Donna, it's going to take a while for recovery. And with that comes the need. So it definitely does have a finite, but it's not going to be months. It's going to be a couple years at this point.
Okay. So Liz, are you seeing an increase in employees calling in sick? And once an employee does call in sick, either because they have tested positive or a member of their household has, what are the next steps?
So that's an interesting question, because we have been dealing with COVID-19 for about 3 months now. But just recently, when the cases spike in Florida, I seen a lot of my staff coming with, positive test results. And our first concern is their well-being. We want to make sure that they are okay. And we also don't want to expose others they are around them. So they have to go home, whether they have tested positive or even if they are just exhibiting symptoms. They need to go home, get tested, follow any medical recommendations from their medical provider, and for sure, they will not be able to come back to work unless we have a negative test results. If it happens in the office, like we had a situation in one of our offices, we actually disinfected. We had the Kent division that takes care of disinfecting that. So they went in with masks and the whole 9 yards and disinfected the facility. And it wasn't until they were completely allowed to go back in, because now the office area was completely disinfected, that we were able to bring everybody back, except for the person who tested positive. That person could not come back in until we have those negative results.
How many people are in your HR department at Kent?
In this Florida office, we have 6 people. We have 2 in New York. We also have staff members in California and Seattle.
And the reason I asked that question, not just to be nosy, was because we've got some associations that are listening that don't have an HR department. They are direct employers, and they are handling these issues with their own employees. What advice would you give them? Hint, call attorney.
Well, you know, it's been an interesting ride this past few months, because we have had to start thinking outside the box when it comes to policies and procedures, right? We are doing things that we didn't have to do before. And the simple things like making employees aware of social distancing, what to do if they are exposed. We have created policies for sick leave, you know, what the steps are to take when somebody tested positive. There's a new law that is called the Families First Coronavirus Response Act, which is an extension of the FMLA, and they are able to request that time off, which will be with pay. OSHA has other guidelines that employers need to follow that perhaps not everybody's aware, especially if they don't have an HR department. So they will need to follow those OSHA steps. And, you know, and just your simple things, make sure that everybody in their area is wearing the mask and observing social distancing.
Well, that's a really important point. I just had this come up with a client yesterday about the FFCRA, the Families First Coronavirus Response Act, and that client was unaware that they had an employee who tested positive, and they said, well, you know, he's got, you know, 4 days PTO time remaining. Well, they actually have to pay 2 weeks, and then they will get that back as a reimbursement on their payroll tax, if I'm understanding that correctly. But, you know, that just came up. The other thing that comes up, frankly, are the Osha regulations. You may have an employee who does not feel comfortable removing, handling trash disposal for an infected or quarantined household, or doing mail delivery to that household. So just some things, listen, if you're an association and you're not using a third party where it's their employees, you have direct employees, if you haven't been on the phone to your association attorney or a labor lawyer, you need to.
Absolutely. And OSHA has these requirements that need to be tracking the cases that they're having. So employers have to track cases of COVID-19, positive or not.
So Andrea, I've been told that these cases are probably going to boil down to negligence cases, failure to maintain the common elements, or perhaps breach of the governing documents, because the governing documents typically have a certain standard for maintaining, repairing, and replacing the common elements. Some documents actually do place an affirmative duty on a board of directors to protect the health and safety of the residents. It's anachronistic language. It shouldn't be in there because it's, you know, these are volunteer boards, but I think that's an important thing. If you haven't looked and gotten an opinion from your attorney as to what affirmative obligations your documents place on you, that's important. But what do you think? What kind of claims are you anticipating related to the pandemic?
Well, the worst case scenario is going to be wrongful death claims. Someone who said, you know, I isolated myself within the building. I didn't go anywhere except for to the mailroom and to the pool, and that was it. And I've, you know, contracted it, and then they either have long-term health conditions or they pass away and we're dealing with an estate or something from that aspect. That would be worst case scenario. I think on average, there's just going to be opportunistic opportunities to file suit, seeing if there's going to be coverage, whether or not it's going to come through. The one thing that I reiterate, and I see a couple times raised in some of the questions to address, is it's not necessarily the liability that a lot of our associations are facing, it's the suability that they're facing. And the fact that if it is not a covered peril under their policies, or it's an exclusion under their policies, the associations themselves are going to bear the expense of retaining counsel and paying. You could spend $60,000, $70,000 if you get expert witnesses and depositions coming in. It could be even higher than that. And the association is going to have that entire expense on their shoulders because the insurance may not respond. If there's some language similar to what you just raised with regards to that proactive obligation on the board to maintain facilities in such a manner, and it becomes a breach of fiduciary duty, but it is a bodily injury claim, a sickness or disease, most directors and officers policies exclusion is extremely broad. It uses arising from or related to exclusion of bodily injury, illness, disease. So if they even touch upon that having been result of their breach of fiduciary duty, the directors and officers policy will likely exclude the coverage moving forward. So it's really more of a defense to
Donna, can I add to that quickly?
Sure.
Obviously when we first started talking about this event, a lot has changed over a 6-week period with the spike of cases. Our position 6 weeks ago, as far as recommendations on reopening your amenities, have obviously changed. But what we've stayed true to is any association considering opening their amenities, that they make that decision as a combined decision with counsel, with insurance, and with management, and you want to have a legal letter on file. But you brought up, and Donna, I listened to a lot of your podcasts, the idea of surveys. Maybe some residents are pushing so hard. So in some cases, they may want to move forward anyway. But I think it's important that they know if they do move forward, that they might not have insurance coverage.
Yeah, I do recommend that, Regan. I actually suggested putting a survey out there to the residents who are pushing so hard to say, are you willing to pay a special assessment for the uninsured claims? They all want it open. Or are you willing to pay a special assessment for the necessary staffing to keep this amenity open? You'd be surprised, or maybe you wouldn't be surprised. It's 99% want it open and 2% want to pay for anything. So, those two things don't coincide. I would ask my Liz, if you can mute your mic when you're not speaking, our panelists, because we did have a little bit of back and forth echo with Andrea. Andrea, I just want to follow up on what we said. Has the insurance industry prepared any sort of best practices specifications for associations when handling the pandemic? Anything relating to cleaning protocols or restricting access protocols? Your industry does this and has done it over the years with regard to things like hurricanes and mitigation efforts. Has the industry come out with anything?
Not anything that's association specific. We've seen it more so for the workers' compensation line items across the board, but not with regards to the associations. I think part of that is more so related to the fact that they're relying most likely going to be on those exclusions that are going to come in. What we do see is a very general pushback of abide by the CDC guidelines, abide by the executive orders for your state, for your county, for your municipality, seek out legal counsel, and make sure you're to the T documenting the work that you're doing. So if you've got the monitor when they're there, when the cleanings happened, who was monitoring, what they saw. So it's more just to have that file for defense should that come down the road.
Yeah, I think the points you made were so important. I think this is going to boil down to a potential substandard duty of care, okay? I also think boards cannot be operating in a vacuum. If you've got things closing around you, the areas where people could have acquired the virus are reduced. And, again, well, let's see. I didn't go to Publix. They had, like in Miami-Dade, they're actually rolling back a lot of the opening. There were no theaters open. They've suspended in-restaurant dining services. And all I did was go to the pool, or I had somebody in my household who went to the pool. And that's pretty much it. So I think it's really going to boil down to a substandard duty of care. And that's where, and to your point, we see meritless, frivolous slip and fall claims all the time. I can't tell you how many times I get a complaint and nobody even knows who this person was who apparently stumbled down 15 stairs and is, you know, now injured for life. There's no incident report, nobody's ever heard of the person, and we have to, but at least in that case, the association can turn it over to their insurance company, and the insurance company will provide legal defense, and they'll get dismissed. In this case, unless they have what's called gap coverage, right, they're not even going to get a legal defense appointed.
Most likely. So unless they have, you know, an unusual policy that's out there, they're not going to. You mentioned gap policies. There's a couple carriers out there who have offered true legal defense only coverage. They don't cover any judgment, any settlement, any depot fees or expert witness fees, court costs, anything along those lines. But there's 2 carriers out there right now that say that they're willing to offer defense where any claims of the association's underlying carrier has denied coverage. We haven't seen them put to the test yet. So that's definitely going to be something a lot of our associations are going to have to take on faith. But at this moment, they're the only ones that are advertising themselves as offering some sort of relief, where right now it appears there's going to be none.
So Darren, I've got to get back to you and ask, is it even safe to reopen pools and gyms and interior areas in South Florida right now in particular, or anywhere in Florida, South Florida in particular? Can it be done safely?
That's a talk about a softball question. Okay. I mean, from a medical standpoint, who knows? I'm certainly not an expert. Andrea's term that she used just before, I thought I was the only one that used it, suability instead of liability. I use that all the time. I didn't even know if it was actually a word. I just came up with it in my head, but now I've got validation. So from that standpoint, it's probably not all that safe, you know. I mean, there's things that you can do to disinfect, but it's not 100%. People wearing masks, people that come in there asymptomatic. I agree with you, Donna. You know, look around what's going on. If your municipality is saying close down facilities, you know, as a security advisor to a community, I would recommend, why take the risk, the added risk, and putting the community in jeopardy financially, legally, medically, and take those steps to open what isn't open around you.
So since you agree with Andrea, and I agree with Andrea as well about suability, tell me what the task force does to provide that backup when a board member is filling out a written interrogatory or sitting in a deposition and they're asked why you kept the pool open or the gym open. Tell me about the logs you keep. Of the steps your people have taken to clean, to address access control, things like that.
Sure. As referenced, I think yourself and Andrea referenced, you know, incident reports, daily logs of activity. Most security companies have a device that the officers are using that help track and log in their movements. So when you go back and you're in a deposition, you can produce those records and show these are where the officers were, this is where they spent their time, the devices are GPS tracked, and then cameras. You know, so after you call your attorney and your insurance company, call your security provider, make sure you got the proper camera coverage. That helps those slip, trip, and falls. You know, cameras are the great, you know, truth when you're saying what happened, what occurred, who was in the spa, who was in the gym, who tailgated through the door, and how did this happen? Well, let's go back to the video and see what occurred. So we always stress.
Are you finding that communities that don't currently have sufficient camera coverage are adding them right now?
Adding camera coverage, and then those that have camera, putting the correct data recording. Most communities have a DVR-based system that only stores the footage 7, 10, maybe 30 days at max. It's funny how people wait to drop those lawsuits to the 31st day when they know the camera footage isn't there. You know, so we recommend putting it on a cloud-based system so it's there. So we're doing a lot of that right now, where they're realizing their recording access is not as robust as it needs to be.
And if I may add to that, I think also, you know, preparing internal policies and procedures to minimize risk and ensure safety, not only for residents, but also for employees, is something that we are ready to do. We have come up with several policies that will help people, you know, minimize exposure and just assess surveys and ensure that the visitors and the employees both are safe.
Donna, we're not, with regards to, there are two different things we're talking about. One is obviously regular security and courtesy officers, and others, direct to your question, was about amenities. We're not going, when people ask, we're not saying, go ahead and open your amenities. But to go back to my prior point, we're saying, speak to your attorney. So some of your question would fall back on you as far as what you would have in case there is a lawsuit, as well as your insurance agent and your management company. So nothing is moving forward without everyone in agreement. And to that point, I would say if someone said, should you open your amenities today? Probably not, but plan, don't wait until the day before in 2 months' time or 3 months or whatever it is. Come up with the plan now. Speak to your attorney, your insurance agent, us, your management company. Come up with the plan, have the procedures in place so that, God forbid, you do find yourself in court, you're ready to deal with it.
Well, Regan, I couldn't agree more, because I think having a plan also will put some of your residents' concerns to rest. I had one resident say, well, are we going to have the pool closed forever? No, we're not going to, hopefully, knock wood, be living under a statewide state of emergency forever. But we are living under a state of emergency until September 6th. So having that plan and revisiting it, and we're going to talk a little bit. I get asked a lot of questions about meetings. Some boards are having more frequent meetings, which I support. Some are not meeting at all. Not a good idea in the midst of a pandemic. It's not business as usual. If you were meeting once a month before the pandemic, you should be meeting more frequently now as you revisit protocol. And by the way, once you have a confirmed infection in your community, you need to reevaluate everything. But Regan, as long as I've got you, I want to circle back, because I had a call from a client the other day, and they hadn't called me. Obviously they'd never watched a webinar or read any of my postings, but I said, well, what are you doing with the monitoring? They said, well, we have one camera at the pool and a basket of wipes out. I don't think anybody on this panel would think that that is sufficient sanitization. They happen to be in Broward County. So with that, there's no monitoring if there are guests using it, which would be a violation of the order. I think reliance upon video cameras, particularly when you do not have 360 coverage of the pool, you just got one camera. There could be a lot going on out of the camera's eyesight. Have you come across that?
Yes, it's interesting you mentioned that, and they add one step, which I guess, and this will be back on you as the lawyer. They put out a clipboard with the waivers, and they believe by making them sign the waiver every single day that there's no liability just based on that. And having listened to you and your counterparts, I know that I don't believe that it does waive your liability. So we see that, and when you don't have a monitor at the pool, Donna, how do you know that the guidelines are being and the ordinance are actually being enforced? I cringe when I see things like that. There needs to be the steps for people to get in, and then once they're in, there needs to be the enforcement. Make sure people are socially distancing. If someone needs to be removed, as Darren spoke about, you do it in a nice way. You give them a warning. If that doesn't work, you might have to call the police. So yes, we recommend, if you're going to do it right, do it properly, because you don't want to be penny wise and pound foolish.
Yeah, well, that gets back to, you're right, and that gets back to the suability and that, answering questions in that deposition, which is, well, what steps did you take in the midst of the pandemic as the numbers were exploding? Well, we had one camera and a basket of wipes. As to waivers, I'm looking at Andrea because she's laughing. We had a conversation offline yesterday about waivers. So here's the situation. Waivers are generally not favored by the courts in Florida and in other jurisdictions as well. In communities, in a condo, the owners have the right to use the amenities because that's an appurtenance to their unit ownership. That's an appurtenant right. So what do you do if somebody says, I'm not going to sign your waiver? You've opened that amenity. If the amenity's open, it's open. Same thing with homeowners associations. The owners typically have rights under their easement rights under the declaration. Waivers are problematic. I do agree with signage. I think signage is important that people know. And I also think it's important that the board get out the protocols on a regular basis. If you haven't communicated your protocols since March 1st to your people, that's a problem. Andrea, anything you want to add about waivers and signage?
No, it's probably the number one question we get asked. Like, well, if we have them sign a waiver, we're not liable anymore, and then the insurance will defend us, right? And so, you know, we kind of have to come back to the beginning and complete the analysis again. And I say, you know, the great thing about a waiver is it makes everybody think they can't file suit against you until they sit down and speak with an attorney. And I said, and then you find out the value behind a waiver. So it's definitely not something that we say is going to hold any weight. And I guess if you've got sign every 10 feet and they're signing their waivers and you're doing the cleaning, that will help you if you get sued, but it's not going to stop you from getting sued.
So I want to save a little bit of time to go through the questions we're getting, because we're getting a lot of questions, but I have just a few more questions I personally had. So Darren, Kent Services has offices in other states. You've got offices in LA, Seattle, Portland, all areas that have been experiencing considerable unrest. Are you anticipating, and Regan kind of touched on this at the outset, are you anticipating any enhanced security needs in connection with either what's going on right now in the world, and particularly the US, or in connection with the pandemic?
Yes, we're getting a lot of questions from clients nationally. Usually it's centered around the question of armed or unarmed, if it's focused on civil unrest and there's protests near their property. You know, what can private security do to protect properties? And I always advocate for a very one-on-one sit down with properties that are asking for that, you know, armed versus unarmed. Because there's a lot of things to peel back on the onion about an armed security officer, particularly in the state of Florida, what they can and can't do. So it takes somebody from the industry to explain all the necessary things that go into making that decision. There's a lot of legal issues associated with it. There's a lot of liability associated with having somebody with a weapon on your property. So yeah, that is a concern for people. And I always invite them to sit down with their attorney, with their insurance, and their security provider and find the right answer. Because just putting a weapon on somebody might not be.
Yeah, up until now, most of the security contracts I've reviewed for clients have been, and I specify, do you want armed guards on the property or unarmed? I would say most of my clients, vast majority, unarmed up until this point, because there are issues associated with that for sure. Those kind of contracts, folks, and I don't want to do a shameful plug for the two attorneys on the panel, but you need to run that by, because there are consequences. So you're going to want to look at the indemnification provisions as well.
And I would like to add to that, we have actually seen a number of clients adding security officers. So we have seen, in terms of recruitment, a great number of requests for security officers. So while other companies are, you know, not staffing people, we in recruitment have been seeing the opposite, a spike of need for security officers, which are going to go and help you to ensure safety and assess risk at these properties.
So Liz, your timing was perfect, because my next question was for you. We've all seen the footage of what's going on. Do you, look, I said this when it came to volunteers. So a lot of associations that hadn't anticipated, nobody anticipated or budgeted for this pandemic, right? They said, well, can we use volunteers? And we actually reached out to Palm Beach County officials, and Palm Beach County officials said, yeah, you can use a volunteer monitor, but basically it's on you. So the counties have kind of punted and pushed it back onto associations. And Andrea will tell you there's risks with that. I always said that if you had a volunteer monitor, if they were doing their job, they had a problem. If they weren't doing their job, you had a problem. Because if those volunteer monitors are doing their job, they could potentially get into an altercation, and people don't like to be told what to do. If they're not doing their job and they're just friendly and they let everybody do whatever they want, the association is operating beneath the requirements of the applicable order. Do your guards have body cams, and have any of them gotten into any potential, any disputes or altercations with people who were told, hey, you didn't clean that, you have to back up, you're not socially distanced, you're not wearing your facial covering?
Well, we definitely have been training our staff and educating them, and how to de-escalate situations. And so they will understand what is behind it to help situations. But definitely haven't seen anything that it's aggressive, anything that's have turned into something physical, but definitely they have to be there when a situation arises, and they will make sure to de-escalate the situation every time.
Okay, I don't think so, guys. I don't think anybody in the 30 webinars I've taken place has asked this question, but I'm going to ask it to Regan and Darren. Do you think we're moving into an era where even private security guards are going to be wearing body cams?
I've encountered that already in my career, where I've had properties that private security is wearing body cams. However, that's like the armed officer question. There needs to be a direct dialogue with the client, with their attorneys, because there are legal issues with where is that footage going, who's storing it, what's the rules for sharing, what was the reporting of interactions. There needs to be training for the officer, because remember, they have to activate that body cam. So they might go into a setting where they're recording things that don't need to be recorded. So it is a step to assist in that he said, she said issue between the security officer and the citizen, but there are certainly factors to be considered before just saying, let's put dash cams and body cams on, because it's not the same as it is for law enforcement.
Donna, with regards to that, it's interesting because I've heard you on your webinar speak with the other panelists. What we say today might be different in 2 weeks' time, right? A lot happens in a couple of weeks' time, but it is something that Kent offers. But I agree with Darren that that's something that you have to evaluate and make sure you're careful before you do. But that is something that is being done already.
Andrea, how important is video footage when you're evaluating an insurance claim as to who's culpable?
From a defense perspective, if we've got videotape, obviously that's going to help significantly. So if we're able to say, okay, the entire complex is monitored and it can go back and be referenced, saved in the cloud, so we can reference back for something that happened 3 years ago, that's going to be absolutely fantastic. With regards to an association on their insurance, a good portion of moving forward is not just the type of claims and the number of claims, it's keeping the ultimate costs down. And so if you have to go all the way through trial to establish you weren't liable and the insurance carrier was on the hook for, let's say, a slip and fall because there was no video, and you're hoping a jury or a judge is going to make a decision, versus sharing video footage with opposing counsel and saying, well, here's what it actually happened. Do we want to continue moving forward? And we keep those expenses very low. That helps the association moving forward down the road. I have one other point to address with regards to armed guards. General liability carriers or associations do not like armed guards. They do not like them. For most of the general liability carriers, not all, but for a good portion, will not even offer insurance for an association if they utilize armed guards, even third party with a contract and an indemnification and a hold harmless.
Even no rider coverage for that, Andrea?
Say it again?
Any rider coverage? Could they get a specific rider to cover that?
You have to go to a different carrier.
You do, okay. Okay, good point.
Well, even if we don't have cameras, the security guards, these days, everybody has a cell phone, a smartphone, and a video is taking place whenever there's a situation. So
yeah, to that point, every time I see something on the social media or on TV, I say, do these people not know that they are going to be filmed? It seems like some people still don't get it, that if you get involved in an altercation, somebody will be filming you without your consent.
Donna, Donna, can I add one thing to the camera thing? Just a positive, not looking at the insurance and the legal side. Having worked in water restoration as well in my career, during a hurricane, and we're in that time, when there's a hurricane and there's a lot of damage to units, these buildings need to be able to give access to the water restoration mediation companies to get in quickly to do the water. And those cameras do come in handy then, because people maybe don't feel comfortable with security or other people coming into their units. That is a tool that they actually do come in handy. I just wanted to add that from a different angle.
Important point. And listen, we've been talking about cameras. A couple things that I'm going to say as an association attorney. Folks, cameras can be a material alteration to your common elements. So make sure, you just don't throw up 5 different cameras without speaking to counsel to see if you're required to get a membership vote prior to doing so. So guys, we only have a few minutes left, and I want to get to a few of the questions because we've got some great questions. The first question was from Ronald, and he said, what can a board do when you have a board member who refuses to wear a mask during the meeting with residents as well? Ronald, I'm going to take this one, and then anybody wants to jump in. Being on the board, while it's a thankless, tough job, it does not in any way put you above the rest of the members in terms of having to comply with the restrictions. So the same thing that applies to everybody else. If facial coverings are required, then that requires your board members to act that way too. And by the way, I have a number of questions like this. Sometimes the board members are the ones that are out there in the pool when the pool was closed, or working out in the gym and not observing social distancing. So the same enforcement tools, whether it's fines, whether you need to get an emergency injunction to tell somebody that they have to stop doing it, that's going to apply to board members. Hopefully, normally in a crisis, it'll bring out the best in people, particularly your board. Hey, board members, you were elected to be leaders in this community. And we are finding that our local government is actually rising to the occasion in many instances, more than even at the national level. There's no more local form of government than your board, okay? So you need to take into account your community's particular risk factors, including if you're in a 55 and over community, or you've got a particularly vulnerable resident population. So I'm gonna take that one. What do we tell our owners who will be returning from out of town? Cat people, what do you tell them?
With regard to?
With regard to the new procedures, basically, listen, the governor's order is still, incredibly enough, his emergency order from early March still requires people coming in from New York, New Jersey, and Connecticut to quarantine. It seems almost illogical at this point because those states have control of their numbers and they're coming down to an epicenter. But are you taking that into account on the task force in terms of checking what's in each order and when it comes out?
Well, so just from my perspective, that's the aspect of your management company. Your management company, number one, should be, as you said, frequently communicating with residents, whether they're in town or they're out of town. And then management should be communicating with your security provider to give them the directives, as Darren spoke about. Every building has different directives. You have your minimum based on ordinances and the CDC, but anything above, security needs direction from management, which goes along with the other professionals of legal and insurance.
Well, you know what? I'm glad you raised it. I wanted to ask that question because what role does management play? Let's say we have a community that only has an in-house manager, no management company. Regan, you were in the management industry for years. And maybe they have one maintenance guy, one manager, both direct employees of the association. What role do they play in trying to manage a building with hundreds of residents?
And again, I'm going to advocate that every association should have a management company just for specific things like this. No one person can be amazing at everything and you need resources. So when you have a management company, you have the resources on site, but you also have the resources at home base and sharing best practices and sharing information and sharing, hey, what did you do with the property right next door? So my recommendation in that case is really, your manager is going to do the best he can. And I know board members get involved. But you really should have a management company, period.
Or outsource it. And Liz, I wanted to ask you, so if you've got people out sick in a community, how do you ensure that critical security and cleaning services are still going to be filled?
Well, we have had to cover a number of vacancies because people have been out sick, and we need to ensure that they are safe without the virus, so they need to go get tested and make sure that they don't have it before they can come back.
So I've got a question coming in from S. Tiger. How can a plaintiff file a suit and not prove they caught it at the facility? Well, this is what we talked about, S. Tiger. It's about, you can sue for anything, and if you can find an attorney willing to find that lawsuit, and it doesn't speak well to our industry at times, Andrea, but they take their shot. They'll take their shot on it. Then it's a question of getting yourself dismissed. look, there's filing suit and then there's successfully obtaining an award or a settlement. These are two different things. So you will unfortunately find people out there that will file suit. I have spoken to a number of personal injury attorneys. I have a few that are friends. Yeah, they actually have friends, personal injury attorneys. But their point is, again, it's about comparative negligence. They don't have to prove 100% causation. What they have to do is limit where somebody could have possibly gotten this, and then prove that the association was providing a substandard duty of care or failing to maintain the common elements in the midst of a pandemic. So that's where it's going to come from. I think this is for you, Andrea. Insurance exclusions most likely did not have pandemics in mind when they were written. With that in mind, what are your thoughts that those exclusions might be tested in court? Oh, that's an interesting one.
I think it's going to
Frank.
depend. Okay, I think it's going to depend on how specifically written the language is going to be. So if it is straight pollutant or contaminant, and you go back to the definition and it's a little bit more broad, there could be a better argument that could be made. When you come back to a form with a very specific communicable disease and virus exclusion, I don't think they need to know that it was going to be COVID-19 or it was going to be SARS or MERS or Ebola or something more basic, just a really bad flu B that season that spread through the whole building. So I think at the end of the day, people need to remember their insurance policies or contracts. These are negotiated agreements. You cover some things and not others in advance. And so it's really important to understand what both sides are obligating themselves to and what they're excluding in advance. We have not seen of those that have tested the virus exclusions, which is separate, attached to the business interruption. We haven't seen any success coming out of those yet, but I'm sure if a major one comes in, but the association is going to bear the brunt of the expense to fight it against the insurance.
Right.
They'll be successful.
So this question is from a client of mine, Antoine, who I speak all the time. Hi, Antoine. This is probably going to go to you, Darren. Does it open it up for someone to sue asking if the temperature device was calibrated?
That's a great question. And not being an attorney, I would say layman's answer is yes. That's why at Kent, we're not really using those handheld devices that go up to your forehead. We're using thermal imaging cameras, which they're refreshing on the calibration, and they're set to block out other atmospherics that could throw it off, and it calibrated to just detect skin temperature. So as clients ask, well, what about the handhelds? If you're going to go down that route and really check body temperatures, get a thermal camera. It's different than the ones that are putting up to your forehead.
Great advice.
At least protect that, yeah.
So this is from Brent. I'm tired of seeing contractors coming in with masks, then past security. I see them in hallways without masks. I want to stop them from working inside the house. So much to stop them. I can take this one. So Brent, if you've got contractors or realtors and their visitors that are routinely violating your protocols, get with your attorney. See, I have banned contractors before the pandemic that were dumping, waste materials where they shouldn't routinely, or realtors that were routinely spreading misinformation in the community. Let's say there's shared laundry facilities and they were telling people it's okay to put in your own washers and dryers. This is a conversation with your attorney, but there is a way, and there have been contractors, realtors, and other people doing business in the building or visiting. There is the potential to possibly ban them again, particularly because we're in the midst of a pandemic right now, and COVID-19 violations are not your run-of-the-mill violations. These violations, whether it's not wearing a facial covering, not observing social distancing, breaking into and using closed amenities, they put people at risk. It's not like you've got somebody that has an overweight cat or is, parking in the wrong spot. These are serious violations. They need to be treated seriously. So that would be my answer to Brent. Darren, it looks like you want to say something.
Yeah, just something that you can add on to that, and security can assist with it. Most police departments are not responding for routine calls now because of COVID. So you can use security to do a incident report, and they can call in a trespass. So if you want to take that extra step and there's a extreme violator on your property, have the security do an incident report. You can call it into the local PD, And that's your trespass warning there. So the next time the person comes back, you can trespass them legally, and they can be detained. So that's
Well, be honest with us, Darren. Do you have a special ops arm for the repeat extreme violators? Do you go in and you cure the problem with some? I'm just kidding. I'm just kidding. But to that point, but that's offline. We'll talk about that offline. But to that point, I think it's a big difference if you've got one or two people who are violating, or you have a group, a large group. And in that case, would you recommend shutting down the amenities until you get it under control?
I mean, I've had that conversation with property managers recently. Yeah, I mean, it seems like if you can't, under the best of circumstances, it's hard for a property manager to control the residents with their own rules. And now that there's certain feelings one way or the other about wearing masks, being in common areas, take that equation out and close it down. It seems the prudent answer, but I understand the forces where residents are pushing on property managers. It's my amenity area and I want to use it. So you have to have.
Well, isn't a little bit of military pressure peer pressure? So if they know that everything's going to get shut down, if they don't fall in line, maybe that'll help get them in line.
I use that argument.
All right, guys, we're at time, and we had some great questions. Perhaps there's a way we can answer some of these questions at a later time, or maybe we just have to do this again. But I want to give you each a chance to just give some final thoughts, starting with Regan, then we'll go to Darren, then Andrea, and we'll wrap up with Liz. You're muted, Regan.
Donna, thank you. There we go. Donna, thank you for having us on. And just to reiterate, at this time, take the time to come up with a plan to reopen your amenities and speak with all your professionals, come up with a combined decision. As far as your amenities go, I like to use the multi-factor approach. The more tools you can add to your policies and procedures to lower the odds, because in my mind, preventing the spread is a misrepresentation. You want to lower the odds of the spread is a smarter move. So it doesn't hurt. It doesn't cost anything. Take your time and do your due diligence before you go ahead and reopen your amenities.
Thanks, Regan. Darren?
I just want to echo what Regan said. Invitation, Donna. We enjoy being here. To all the communities that are listening in, use your security vendors as a security advisor. That's what we are. As hopefully you can see, we're gaining our ideas from statutes, talking with your attorneys and your insurance carriers. We're here to help you make the smart decisions. So lean on us. That's what we're here for.
Thanks, Darren. Andrea, my Midwestern neighbor, I don't know if you knew, I grew up in Chicago. Did you grow up in Missouri?
No, I didn't actually. Was out there for a number of years, but story for a second. Born and raised Florida native. So
Oh, wow.
I know.
Very rare.
Very rare. You got it. Palm Beach County native. Good. So for my associations, my best example is an association that I heard of that reopened everything up, and now they're in the process of closing it down. And as they're closing it down, they started saying, well, we just spoke with our attorney and we've just spoken with our insurance professional, and now we realize everything we didn't realize before. So the best thing to do is to sit down now with the attorneys and the insurance agents and understand what your policy does and does not cover. Understand how you're going to make your decisions based upon that. And if I'm a unit owner, I want to know within my community, if we don't have coverage, do I really want to be assessed for the right to be used in the pool in case we get sick? So knowledge is key.
Absolutely. I mean, this is not the time to stick your head in the sand as a board member. Look, there is potential personal liability for Florida condominium directors under 718-111-1D if they show a wanton disregard for public safety. Then again, we have some documents that actually put an affirmative obligation on board members to protect the health and safety and welfare of the residents. So I don't mean to scare anybody off the board. I served on my own board of directors in my homeowners association for 2 years, and it was tough enough back then. The only thing we were dealing with were palm trees and mailboxes. So I can only imagine really a debt of gratitude and thankfulness to everybody on the board. But to Andrea's point and all our panelists' point, this is the time to get the proper advice from the professional advisors with whom you surround yourself. And with that, Liz, last thoughts?
Yes, I would say for these individuals to make sure that they have solid procedures in place, policies and procedures, and not only for residents and visitors, but also for employees, and use those services those resources that are available to you. We've been talking about insurance, and we're talking about the different liability reasons. Exposure can also be minimized by creating internal policies that will help you minimize exposure to a lawsuit, to getting infected with COVID-19, and just be very mindful of what are those things that you could do to minimize risk with these policies, with everyone in mind, not just your residents, also your staff.
Thank you. I want to thank all our panelists. Thank you so much for taking time out of your days to sit and talk to people. For everybody who tuned in, thank you so much. You know where to reach each of us. You've got our email addresses. If you had follow-up questions and we didn't get to it, feel free to email us. We'd be happy to, I think I can speak for everybody. We'd be happy to respond to your emails, and stay safe out there. It's not always we will get through this crisis. But it's going to take leadership. So be leaders. Thanks, everybody.